Hello everybody. I am going to provide a lecture in regard to constitutional law. I miss you guys and I'm really sorry that we can't be together in the classroom. As you know, it's a lot of fun for me and I really enjoy the interaction we usually have between me and you guys as students and the questions and that kind of stuff. So I beg you to bear with me and we're going to try and make the best of what's kind of a difficult time. In addition, I again want to make sure that everybody understands that if you hear that someone say coronavirus is a hoax, that please do not listen to that. That's just not true. This is a major issue and problem, and I want you all to stay safe and stay healthy. And hopefully in a couple of weeks we'll be getting through this, and maybe some of you can come back and visit and that type of thing, and that would be a lot of fun. What we're going to do at this point is I'm just going to provide you a weekly lecture on different areas of law that we talked about. As you remember, we've started talking about substantive law. And the first thing that we were talking about was constitutional law in the United States. And in that regard, you have read Carper Chapter 2. So I'm going to be going over some of the material in that. And for next week, what I'd like you to read is Carper Chapter 6 and Baum Chapter 6. And we're going to finish off criminal law, and we'll start talking, we're going to finish off constitutional law, and then we'll start talking about criminal law. All right, so the first thing that we've already done is we asked, what is the significance of the United States Constitution? What is constitutionalism? Do you need constitutionalism for a constitution? And we talked about how you did not, that a constitutionalism is a particular type of constitution. And then we went on to say that constitutionalism is not even a necessary requirement for democracy. And that even, if you think about it, the existence of a constitution itself is not a necessary requirement for the Constitution. And what we want to do today is, building upon that, ask the next major question, which is, what are the major elements of constitutional law? So we have this document called the Constitution. And the question we want to know is, what does it do and what do we mean by constitutional law? And in this context, what we want to emphasize is that there are two major functions that our Constitution, the United States Constitution, provides for us. First, it establishes government structure and government power and how our government functions. The second thing it does is defines the rights of citizens in the United States. And what we want to do is look at both of those components, this whole idea of government structure, power, and functions first, and then rights of citizens. So let's talk about the whole idea of government structure, national government structure and functions. When we talk about national government structure and functions, what we have to understand is that when we look at the original Constitution, that's all the Constitution was originally about. So when you look at the Constitution and you open it up, and the first thing you see is Article 1. So there's a preamble and then Article 1. And the original Constitution was just a series of these articles, 7 articles. And what these articles concerned themselves with was the establishment of our government and an explanation of how it should operate. So when we talk about government structure, we're talking about Articles 1, 2, and 3. Article 1 gives us the legislative branch, otherwise known as Congress. Article 2 establishes the executive branch and talks about the powers of the presidency. Article 3 talks about the judicial branch and establishes Supreme Courts and courts inferior to it. And Article 4, as well as later on the 10th Amendment, talk about issues of state power. Now, collectively, what we know is that when we talk about the establishment of our government structure, that it gave us 3 branches of government. It gave us this notion of checks and balances. It gave us this idea of separation of power, and it gave us this idea of federalism. And the thing that we should understand is that the Constitution doesn't specifically use these terms in many cases, so it doesn't specifically say this is checks and balances. It doesn't specifically say this is separation of power. It doesn't specifically say this is federalism. But the document as a whole, in its aggregate, represents those concepts. So we establish 3 branches of government. We give them each individual powers, lawmaking powers, executive powers, interpretive powers. And then in addition to that, we talk about how one branch of government has oversight over the other branch of government in many different ways. So, only Congress can pass laws. We know that, because Article 1 tells us that. But the President of the United States can veto them. The President of the United States has to execute the law. But we also know, according to Article 1, that Congress has the power of oversight. So we have these notions of checks and balances. And when we talk about constitutional law, and we talk about this first function of national government structure and functions, what we're saying is that the Constitution is trying to explain to us what the powers are and how they relate to each other. So the courts, for example, in the area of war-making power, has to interpret Articles 1 and Articles 2. So the Constitution says that only Congress can declare war. But then it also says that the President of the United States is the Commander-in-Chief of the Armed Services. So the question often becomes, okay, to what extent does the President of the United States need the approval of Congress to commit troops into imminent hostilities? So, I mean, we just saw that not too long ago. We saw this situation where we came into a conflict with Iran. We then killed their general at their airport. And Iran was saying, we will retaliate. And then President Trump said, if you retaliate, I will bomb numerous sites, some of which are military, some of which are religious, some of which are cultural. Does the President of the United States have the authority to unilaterally decide whether or not we're going to bomb another nation? And that became an issue of dispute, and is still currently an issue of dispute. So Congress is passing war powers statutes that try and define exactly what the President can or can't do in this regard. And by the way, one of the arguments is if you start bombing religious or cultural sites, it's a violation of international law. So when we talk about constitutional law, we talk about this idea of governmental structure, the Constitution has to be interpreted to tell us what these different provisions mean for what the president, for what Congress can or can't do. And that's an important issue. So for example, if you have your book, I'd like you to open it to page, and I'm talking about the Carper book, page 39. And they give you a case. They said, in 1997, Paula Jones filed a civil lawsuit for money damages against President Clinton, alleging sexual harassment while he was governor of Arkansas. President Clinton asserted executive privilege as justification for his request to suspend the litigation until after his presidency ended. And the question was, does the U.S. Constitution provide presidents with such an executive privilege to delay civil litigation? And then when you go to page 40, it gives you the answer. And the answer it gives you is no, the president cannot delay civil litigation. And it's in this case, the president contended that ongoing civil litigation would impair his ability to lead the nation. Thus, it should be suspended by executive privilege. The president was subsequently subpoenaed to appear and testify in litigation, and he agreed to do so. Oh, why do we mention this case? Because this is exactly what's going on right now, right? So, we know for a fact that President Trump is an unindicted co-conspirator in violation of election laws. That's true. He is subpoenaed. He has refused to appear. We have subpoenaed people within his administration, and he has told them that they can't testify. Don McGahn, his lawyer. He also said Flynn should not have to testify. He's talked about his national security advisor and how he can't testify. And the president has said all along he will not comply with subpoenas. Can the president of the United States not comply with a congressional subpoena? I mean, that's a pretty interesting question. That's a question of governmental structure. That's a constitutional law question. Another example the book gives you. Page 44. And I'll read that one. It says, Congress presented the fiscal year budget for the year 2004 to the President for signature or veto. Included was an item for $10 million for parks and recreation projects in Congresswoman Peavy's hometown. For years, Peavy had been a very vocal critic of the President. Can the President approve the budget, yet in retaliation veto the proposed appropriation for Peavy? And again, the answer the book gives you is no, the President cannot. The power to make partial vetoes would have the practical effect of amending enactments by Congress. The President is not authorized by the Constitution to amend laws proposed by Congress. Thus, the separation of legislative and executive powers cannot be blurred by these types of vetoes. Well, wait a minute. Didn't we just go through that too? Didn't President Trump take money that had been appropriated by the United States Congress to the Ukraine for their self-defense and remove it, impound it, And he said he had the right to do it, that he could do that whenever he wanted. Really? Well, as I've suggested to many of you students before, I have never seen in my lifetime a president who has more of a disregard for the rule of law. And this has nothing to do with ideology. It's not about being a Democrat or a Republican. It has to do with what do you think about the rule of law. So you can see the importance of understanding constitutional law in terms of its impact on the operation, even in a very practical way, of our government. And we could give you other examples, but I think you get the idea. And within this context of governmental structure, one of the other things that constitutional law does for us is it defines this idea of federalism. Federalism. So, in the United States, we have a unique form of democracy that most democracies in the world don't have. And it's called federalism, which is the sharing of legal authority and power between national and state governments. And again, the term federalism is not really used in the Constitution. That term is implied from what the Constitution provides. So, the Constitution talks about national power. So Article 1, Section 8 of the United States Constitution tells us the powers of Congress. Article 1, Section 9 talks about the limits on national government. Article 1, Section 10 talks about the limits on state government. Article 4 talks about state government powers. And as we said, the 10th Amendment talks about state government power. So when you put these all together, you get this concept of federalism. Of when can the national government pass laws? When can the state government pass laws? What happens if national and state government laws conflict? And one of the things that we've said is that when we talk about federalism, federalism does not provide for a strict hierarchy. In other words, national laws, if they conflict with state laws, don't always win. Matter of fact, state laws can sometimes supersede national law. It depends upon how the Constitution defines the powers of governing. What it says the national government can do, what it says the state governments can do. Now, within that context, if the national government is given the authority and power to legislate in regard to a specific area, like we said, Article 1, Section 8, then its power is supreme. But by definition, as the Supreme Court has recognized, the national government is limited in the powers that it's provided. So if it's not a power of the national government, then by definition, then in accord with our Constitution, then in accord with the 10th Amendment, it becomes a power of the state government. And therefore the national government cannot preempt it. The only time the national government can preempt it, and we talked about that in the context of what's referred to as the Supremacy Clause, again, is if it is a specific power of the national government. Now that's a tricky kind of statement, though. Because sure, we have Articles 1, Section 8, which lists these powers. But one of the things that we also know, we'll talk about this later on, is that the United States Supreme Court has said that Article 1, Section 8 provides the national government with enumerated and implied powers. So the very last statement of Article 1, Section 8 is referred to as a necessary and proper clause, which says that Congress has the right to pass any law which is necessary and proper to carry out these enumerated powers. So in other words, not only does national government have the powers that are enumerated, but if they're necessary and proper to it, it can also do that. And that leaves this whole idea of what the national government can or can't do up to significant interpretation by the courts. Is something necessary and proper or not? And what you'll often find is the states and the national government can't agree. So the courts again have to intervene, have to interpret constitutional law and determine who can do what. And your book provides examples of that. So example on page 53, and we'll get back to it. It says an Arizona statute made it unlawful to operate a train of more than 14 passenger cars or 70 freight cars within that state. The law was a safety measure and acted under the state's police power. Was such state regulation of train lanes lawful? Is it lawful? Or is that the power of the national government? So the book says, no, the state regulation was not lawful. Trains moved into and out of Arizona from other states. And interstate commerce is subject to federal regulation under Article 1, Section 8, and the Arizona statute unduly burdens interstate transportation. So because it deals with interstate transportation, only the national government can regulate it. Okay. So that's the first major function of constitutional law. The next major function of constitutional law deals with the right of citizens. And we define these rights of citizens into two major categories: civil liberties and civil rights. And I'm going to talk about civil liberties first. Civil liberties deal with individual rights. So civil liberties are freedoms from government interference, such as freedom of religion. You can practice whatever religion you want. Freedom of the press, freedom of the speech. You have a right to free political speech. If you want to say Nancy Pelosi sucks, you can say that. You can't be imprisoned for that. And when we talk about civil liberties, these freedoms are specified very specifically in the United States Constitution in what we refer to as the Bill of Rights. The Bill of Rights. And the Bill of Rights are the first 10 amendments to the United States Constitution. First 10 amendments. So in other words, the Bill of Rights weren't even originally a part of our Constitution. Matter of fact, it was Jefferson when he came back from France and he looked at the United States Constitution and said, whoa, what about our rights, guys? You talk a lot about government and how it should be structured, but you don't say anything about what citizens get out of this deal.
So as part of the debate over the adoption of the United States Constitution, the proponents of the Constitution agreed that after its adoption, they would add a Bill of Rights immediately, which is what they did. And these are the rights that we're talking about that provide us with individual freedoms. Now, when we talk about these individual liberties, I call them individual liberties because what we're saying is that these are rights that every individual in our society has. And if government does anything to violate even one individual's right, then that is unconstitutional. So it's not about how many people's rights we're violating. It's not whether the majority agrees and the minority disagrees. If one person's rights are violated, it's a violation of civil liberties. Now, when we talk about civil liberties, we usually divide these liberties into these individual liberties versus what we refer to as criminal protections. Criminal protections. So, just as an example, when we talk about individual liberties, we're talking about things like the First Amendment. So the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. So the First Amendment is often considered to be the heart of the Bill of Rights, to be the heart of this idea of individual liberties. And it was Justice Black who actually made that analogy between the First Amendment and the heart. And he said that if we violate the First Amendment, it's like the heart stopping and we will die. So he's talking about it metaphorically. If we don't enforce the First Amendment, we will die as a society. Because these beliefs, these freedoms are essential to our society. So the First Amendment, the Second Amendment also deals with this idea of individual rights. And then we have things like the right to privacy. The right to privacy. So, First Amendment, religion, free exercise, establishment, free speech, free press and assembly. Second Amendment, which was the last to be incorporated, the right to keep and bear arms. Is that an individual right? That's why it was the last incorporated, because some people didn't think it was an individual right. It only applied to the militia. The right to privacy. Do we have a right to privacy? And what the heck does that mean? Well, the right to privacy is kind of an interesting individual liberty. Do we as Americans have a right to privacy? And this almost becomes a test of how you interpret the United States Constitution and what judicial philosophy you apply. And why do I say that? Because there's nothing specifically in the United States Constitution that mentions the right to privacy. But can a state outlaw the sale and possession of contraceptives? Griswold versus Connecticut, a real case. And it was in that case that the Supreme Court comes up with this right to privacy. And how do they do it? Well, there's not a specific amendment that says right to privacy. So they say that there are specific guarantees in the Bill of Rights that have penumbras formed by emanations from those guarantees that help give them life and substance. What the heck does that mean? I mean, this is some of the most confusing language I've ever read in a judicial opinion. I can remember as a student reading Griswold versus Connecticut and having to hold on to the desk. I thought we were going to float away. What? What? Try to read it again. Specific guarantees in the Bill of Rights, right, First Amendments, have penumbras. I didn't know what the heck a penumbra was, so I looked that word up. Formed by emanations, wasn't too sure what an emanation from penumbra meant, so I had to look that up too. From those guarantees that help give them life and substance. Emanations from penumbras. What in the hell does that mean? What? A more colloquial presentation on what that means. What we're saying is that every Bill of Rights has areas that are gray areas that surround it, that it implies, and that you can argue that when you look at these things collectively, even though it doesn't specifically state it, it is assuming certain kinds of rights and protections, one of which is this right to privacy. All right? So if you believe there's a right to privacy, then it's hard for you then to argue that you believe in strict construction of the United States Constitution or a four corners of the document approach. Because, again, there's nothing in the United States Constitution that specifically says this. And we're going to get back to this. So we said that civil liberties are divided into individual liberties and criminal protections. So when we talk about criminal protections, we're talking about the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and the Eighth Amendment. And I separate those out because one of the things we do here at Mount Union, and law schools do this too, is generally when you talk about constitutional law, we break it into three topics. When we talk about substantive rights, we break it into civil rights, which we haven't talked about. We break it into civil liberties, which we then break into individual liberties, and criminal protections. And you have courses on all three of those things when you go to law school. So when we talk about these criminal protections, that will not be something that'll be in your constitutional law course. That'll be in a separate course on criminal law.